Okay, good afternoon. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our September 27, 2018 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of inter-multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecute parties who violate the law, the Loft law, and Loft board rules. Today, we are gathered. Today we're here solely for the purpose of rulemaking, and the discussion is going to be. The discussion is around the proposed changes to Section 2-09B, which concerns protected occupancy. Before we launch this discussion, Ms. Julie Torres would like to make a statement.
Oh, sure. Yeah. Hello.
Just,
Yeah, it should be on.
Just move it.
You have to press the button.
Oh. Hi. Just make sure it's on. You guys are very on.
You can take it out.
I just wanted to make a quick clarification from last Thursday's meeting. Take it out. Okay. Last Thursday's meeting, we were having a discussion about a case. Am I allowed to mention the case because we voted on it?
Well, it was tabled. There was
A tabled case. Can I mention what it was about?
yeah.
So the tabled case was about a tenant who was made an agreement that he would leave for construction for 3 months, and it took 11 months. Conversation ensued, and I was making different points, one being, but I would never want to give advice. I'm an architect, and there's a tenant protection plan, and there's safety, and of course construction can be dangerous in many different ways. So I never would want anyone to construe that I was advocating staying in your apartment during construction. I always, on my practice, people leave. That's much easier for the contractor too. But what I was speaking about was just, I was mentioning public perception that that if you leave an apartment, that you are then vulnerable to never being back. That's like a fear I have as a tenant. So I just wanted to clarify, my opinion is not that you should stay in your apartment if there's dangerous construction. That's not what I'm saying at all. But there is a perception of when you leave that there's a reason why this would be fruitful, that you might not be able to get back in. And that case was showing how much longer, and I've seen it happen where, this can really break a family that thinks it's 3 months and then it's 11 months. That was my point. Thank you.
Thank you, Mr. Torres. Okay, Mrs. Paulson.
Okay, so I distributed to the board members, and we do have copies for the public if they haven't gotten them already. We're talking about this document that just has the protected occupancy rule pulled out in the beginning. I also added sales rights and penalties, and I think that perhaps we would get there. So the beginning of this section is a deletion. So it starts with B, occupant qualified for possession of residential unit and protection under Article 7C. And that's, all that text is deleted. And I realized as I was looking over it earlier this week that I actually deleted more than I intended to. Originally, when the rules were drafted, we were going to break this section into 3 separate rules. But we actually have pulled back from that. So the deletion is going to change. It will go from, you see the little bracket before the 1, it will go all the way down to the 4. And then in the middle of the 4, 4 says the prime lessee or sublessor who is not the prime lessee is deemed to be be residential occupant qualified for protection under Article 7C if the primacy or sublessor can prove that the residential unit covered as part of an IMD is used for primary residence, even if another person is in possession. So that would be a period there, and then a new number for the rest of the section, and the rest of that text will stay as is. Okay, so the next section would start with, if the primacy or sublessor fails to prove such unit is his or her primary residence, any rights of such person to recover the unit are extinguished, et cetera, et cetera, et cetera. So I will show you that renumbering next time, but the text beyond that part is going to stay in the rule as it is, unless, of course, the board wants to change it. That's perfectly fine too. So I'll show you the renumbering and put it all together next week.
I'm sorry, if I understand you correctly, the proposal now would be that section 209B is to read as follows. So the first words would be the last sentence of number 4?
No. We're going to delete what is now 1, 2, I guess 3,
Right.
and part of 4, right?
Part of 4.
We're going to put in the stuff that's added after that. Okay? So if you look at page 2, Joe.
Let's say on page 1, tell me where the bracket goes. Now.
Where does the bracket go?
Yeah.
Sure. The bracket goes, even if another person is in possession, that should be a period and a bracket.
Right.
Period will be underlined.
And the next sentence, the now sole remaining sentence in number 4 would be, if the primacy or sublessor fails, that's going to go somewhere else.
We'll go under the text that we're going to be replacing this. We're going to replace the stuff that's being deleted, and this material that's remaining will go after that material. And the board will see that with 2 weeks' notice before the next meeting. Okay, but I just wanted to point out that I deleted too much.
Thank you.
Okay. All right, so that brings us to the proposed rule. So the first portion, the first so-called new portion, is a protected occupant registered with the law board must be a natural person. Yes.
And prior to jumping into the text,
Yes.
I think you really do owe us an explanation as to how we got here. Because last year, we were talking about the same thing. And it was never explained to us why the issue was tabled, and now here we are again talking about it. So yes, I think we should understand first why we started and why we're starting.
So the board members and also additional people outside the board expressed some concern that the scope of the rule changes that we were proposing was too broad, and we were asked to roll it back, so we did.
I find myself in complete agreement with Mr. Carter, and a little explanation would be helpful.
Okay.
Yes.
People were unhappy with what we were doing, and we were asked to stop what we were doing, so we did, and we're doing more and we are proposing more modest changes.
But just on, I understand the grand scheme of extensive revisions to Chapter 2.
Yeah, that doesn't seem to be right. How do we,
This poor lady has to transcribe what I say, so I'm trying to do my best.
Yes, press the button.
Press the button.
There we
Yeah,
go.
okay.
maybe turn it so Mr. Carter's.
I'll be happy. The more sweeping proposal to revise Chapter 2 is one thing, but in particular with the protected occupant provision, the last time we were discussing this, we were looking at 4 different flavors. At that point, we're 1, 2A, 2B, and 3. So I think the question that I presume you were asking is on this topic, how did we get to this point?
Right. Although I wanted to talk about the about the options also, but my question was, as Chuck says, why did we stop talking about this particular topic 9 months ago?
What is that getting us right now? We need to get to rule. I mean, why do we need to go back 9 months? I don't even remember what happened 9 months, a month ago. I mean, 9 months ago, we stopped, and as Renee said, there was some inquiry and concerns that the board, the rules had to be scaled back with what was proposed. And we're pursuing this now. Why do we need to go back in history as to what was before us? I don't understand.
Well,
This is your rules, by the way.
because I think that outsiders, I think that politicians are trying to influence the board, and that the rules may not reflect, the rules as proposed may not reflect sound policy and are instead the wishes of someone in politics.
Can we as a board debate these rules outside those influences and come up with a good set of rules?
Yes, of course, but that's part of the debate.
That is where we want to go right now, and I think we're being distracted a little bit by just going through these, and if we have these kind of debates back and forth, we'll never get to finish.
I know, but you guys are the ones who stopped the process.
That was, as you said, 9 months ago.
9 months ago. Well, let's talk a little bit more about, so the board itself directed the executive director to give us options because the sole option that had been presented was admittedly, you guys, the most controversial and extreme of the proposals. We asked for options. You gave us options. We were debating options. One of the options was characterized by the staff as the most viable. And here we are today, without the options, back to the very same proposal that sparked us asking for options. And you now want to jump into this without even explaining what happened? I mean, what's that all about?
So I found that having all the options was very difficult to deal with. It was difficult for me personally to deal with. I think it was difficult for the board members to deal with. I think it's good to have a place to start, and if you don't like what the proposed rule said, then we change that. What the proposal says, then we change that language, and then we come back with the redrafted language. But having 4 different options on the table, I think was not working for anybody.
But it wasn't, but we're the ones who asked for it, we're the ones who were working with it. And suddenly they're gone? I mean,
I don't know that we were working with anything. All we had was like a whole bunch of stuff that nobody was really paying attention, that nobody was really focusing on because we couldn't focus, or at least I could not focus.
So let me ask for focus. Does this reflect any one of the 4 options previously discussed?
Yes.
Can you say which option that was?
No.
Is it some combination of different options that you combine together?
It could be, honestly, I don't remember.
no, this is the very original proposal that we asked. I mean, we didn't say up or down we wanted it or not, but we wanted to at least consider less extreme possibilities.
So then let's talk about that in the context of what's here. If you don't like what's here, then say, I don't like what's here, and I think we should change it this way. And then the board can discuss it and make a determination on that. I'm fine with that, but I think having 4 different starting points is just not manageable. So here's a starting point. If it's not good, then we change it. We've done that with other portions of the rules. Nobody asked for multiple options on other portions of the rules. So let's just follow that same procedure here, and it will evolve. I don't expect that this is going to be what the board's going to adopt. I assume that it's going to evolve as a result of discussion.
Okay, so could you first explain what the problem is that you're trying to solve by changing the existing rule?
So there are a couple of problems. One problem is the question of primary residence. And I had presented a slide presentation back in last September. It's actually almost a year ago to the day, tomorrow would be a year to the day, where I talked about the concept of primary residence, whether or not it should be in, shouldn't be in. The law actually does talk about tenants continuing their occupancy if they use the unit as their primary residence. And it was very unclear as to who needed to use it as a primary residence. There was a different standard for prime lessees or sub-lessors who are not in possession, as opposed to people who are occupying. And so that was a point of contention. So one goal here was to try and clarify and say, you have to live there. Here's when we think you have to prove that you live there. We're not going to use the standards in the housing court because our units are different and people will not have the same kind of proof. So that was one push that we thought was important to address. The other issue was the prime lessee trumps all, right? So the board's cases have evolved in a way that the prime lessee, if the prime lessee is using the unit as a primary residence, nobody else basically can be a protected occupant if the prime lessee is living there and is claiming that they are a protected occupant. So, based on a lot of feedback from a lot of people, as well as earlier cases, there's really a question as to whether or not that was the intent. One of the purposes of the loft law is to prevent dislocation. Would we, if we continued along this path, be dislocating people? So one of the proposals is to eliminate that prime lessee trumps all line of cases and clarify the rule to say that if you were there on the effective date of the law, regardless of whether or not you're a prime lessee, you can stay and be a protected occupant. And, well, yes, unless there's other things that are going on which would cause somebody to want to evict you. And if you were there after the effective date of the law with landlord consent, you could also be a protected occupant. So that's the proposal. Will that pass? I don't know. You have to discuss that.
Okay, so what I think what you're saying is that the current rule is not accurately reflecting the intent of the legislation. I think I heard you say that.
Yes, I think to a certain extent that's true.
So, prior to jumping into the rule itself, I do want to explore that concept.
Okay.
Okay. So, last year, I had pointed out parts of our actual statute, the loft law, that I thought
keeps up. And we just have to bring ourselves up to date with the real world. And not go along with, I mean, we got this thing with the spouse that seems to be incredibly unfair. But what happens if the landlord gives the spouse or the leftover a new lease? Then does that person become a PO? And the answer is no.
Yes. Under the current rule, they would. Right? Because that's consent.
But if the landlord keeps taking the rent from the spouse, whether husband and wife, with the left spouse on the lease, then what is the answer? So yes or no? Does that person become the protective occupant?
That's a harder case because you have to see, I mean, you could argue, there would be an argument, I think, to make that the landlord accepted all this rent from me, so clearly the landlord is consenting to my occupancy. That's an argument that would be made. Ultimately, the board would have to decide it. That I think is a case-by-case basis. It's a harder case than if there's any rental lease. It always is good.
there's a good, I mean, there are some good practical reasons why when a lease exists, it should be given a preference, by the lessee should be given a preference. There's a sense of permanence that comes with a written lease as opposed to someone just being a roommate and who is an occupancy without a lease. Yeah.
Chuck and Robert, actually, when we were approaching this the first go-around, just refresh my memory, maybe we weren't referring to this particular topic, but didn't we have some sort of discussion that we should possibly consider trying to find some real-world folks that these things affect, and having them speak before the board. Am I thinking about something different?
It's a different issue. That was
the sale of rights.
Just the sale of rights. Okay.
But it's a great idea in this instance as well. You know, I mean, but to some extent, look at some of the crazy cases we've decided. Ukai, where the husband moved out, the mom, and the son, we were having a hard time deciding whether the son was a protected occupant. Shus, I believe, is an abomination. It's really just crazy. And there have been a dozen.
It seems to me, and maybe I'm wrong, but it seems to me that there's gridlock amongst the board here, not in any type of a hostile way, but in a simple way of uncertainty and in some cases lack of being able to relate. I guess I personally feel that an opportunity to hear from real world folks that these things affect would have some benefit and some merit in some of us perhaps clarifying our thought process of where we need to go with this. I'm just making a statement, I'm not really trying to open up a debate.
I'm sorry, the chair recognizes this.
Oh, no, I like very much what you were just saying. So, it's fine that you were speaking. Along Elliot's line, I thought, bringing it up to date, there was that case the other week about family, was that an argument?
10th Street, 15 Thames, where we said that's too big, the judge said you're wrong, they can have a family.
It wasn't, the board made a decision, it was reversed in the court, am I right?
Yes.
Where a family is, a family can be recognized as roommates that eat together and pool their money together?
Yes, that's correct.
Well, one of the options that was proposed, not that I supported it, was allowing people in a common household to have to be on an equal plane. Let's see. I don't support that. I think it's too broad. But that was one of the ideas that was being proposed last year. When we stopped talking about it, that was explained.
No, can I just say that at the public meetings, unless it's a CAPA public meeting where we're getting comments, the public isn't allowed to talk to us.
Just that we're here.
But we will actually hopefully get to that point one day when you will be able to stand at a podium and tell us what you think of this proposal. But we have a long way to go.
Yes, and we will be able to do that. However, in my experience, by the time we vote out proposed rules, it's pretty much a done deal. And in this one, I think we're
So
dealing-
can I say that in my experience, that is not true? I did rulemaking for ECB for many years, and when we had public comment on rules, and there was a good reason for the board to change what was proposed in the rules, the board changed the rule. So in my experience, that has not been the case. So that's where I'm coming from, John. I am open to, Mr. Delaney, sorry, I am open to changing rules if the public makes comments and the board wants to change the rules. That's the way it's supposed to work.
Well, I understand that, but would it be easier for us to have an open meeting for our next meeting and then go into this rule, rather than do it after the fact?
We'll never get
That's just a suggestion. Well, I mean, we'll never get to the end of it, but you know, I don't know whether we're in gridlock here or we're not in gridlock.
What would be sufficient? And I don't mean that.
Sufficient for what?
Well, if we're going to have a public meeting, how many people, for how long, would we have a review of the different kinds of speakers from different configurations? Will we limit it on the basis of different groups so that we don't have all one group versus another group? Would we try to get geographical diversity? How would we get it in terms of, you know, the different types of residency or the different types of buildings? What is the proposal? I mean, we could spend, you know, I think, Chuck, you would agree there's a significant diversity of buildings, neighborhoods, ownership structures, different unit property situations, let alone getting into the different configurations of the groups and the residents. And I say that with respect, so that if we're going to broach this idea, then, I mean, when we have a public comment period for a rule, when we actually say, hey, everybody, this is what we're thinking about, come in and tell us what you think. And then at least some of us actually listen, and then try to talk about what people have told us. How long a comment period is that? And how many speakers come in?
So we can make the comment period as long as we want. My understanding from other statements Mr. Levy has made in the past is that it has been hours.
Right.
Okay, maybe days.
But here,
People get
Yes.
3 minutes. There was an issue about whether, and there was, we had been asked, well, you know, they go more than 3 minutes?
and they frequently do,
Well,
and they go
no.
on and on.
So, you know, and what I said at the time, and I will reiterate it here, is that everybody who comes to speak should get a chance to speak. So you get 3 minutes. If there's nobody in the room,
Yes.
talk for 3 hours if that's what you want to do. If there's a really crowded room, everybody who has made the effort
Right.
should have an opportunity to express their
Right.
opinion.
But-
And we can hold the comment period open for further written comments. We checked this with the law department. We can hold the comment period open for further written comments from members of the public if the board had questions that they wanted to answer, or if the public wants to put in additional comments. I'm sorry, Mr. Roche.
No, I believe we could orchestrate it, that they would need to reach out to the law board and register in some format, that may be the wrong word, that they want to speak on that day, so that their name would be on the list of people that wanted to speak, so that it could be regulated and not turn into a never-ending forum. Is that not a possibility?
Honestly, I don't know. I mean, I'd have to look that up and see if that's okay. There's a part of me that thinks that that's not fair. You know, what if you can't register in advance, you're not sure whether or not you can make it on that day, but at the last minute you manage to get off from work and you really have something valid to say, shouldn't the board be able to entertain that? So, you know, it's a balance, and again, it's slowing things down, and we are again off topic. It's slowing things down, right? We're not talking about the rule, we're talking about maybe doing something else to do something else about the rule.
Can I ask, can we get back to if I understood it correctly, the initial question, which is, I mean, the base idea of a rule is that it's supposed to fulfill the law. And so I think that was the base question, was whether the rule as it currently is accurately reflects the law or not. Because if it accurately reflects it, then however much we might wish it were otherwise, however much we might feel that there's a public need for it to be otherwise, we're stuck with the law that we've got. So before we go further and hear in greater detail about needs that, you know, that that should be addressed, the first gatekeep, my sense is the threshold question is, can we legally do so?
So I would make a proposal that I felt was ultra virus, since
I
it's already in
understand,
the law.
obviously, this-
I think that the current rule is within the ambit of the law. That doesn't mean that there aren't other, that you can't amend the rule in such a way that it would still be within the ambit of the law, but accomplish a broader end, I guess is the way to say it.
Mr. Chairman, at this point, I would really respect your opinion and input at this point. Any thoughts?
I thought it was,
We've been quiet for a little while.
I think a better word is that implementation.
Okay.
Because I think this has been, we've debating again stuff that was, and I hear some of the same questions from the board members that we've gone over so long ago, and knew this coming in even last week actually, we said we're going to talk about this, and this is the only thing we're going to debate these rules. And it seems a little derailing here of the process for us to continue this instead of just looking at what's in front of us, seeing what we like about it, making our suggestions for changes. This is your rules, this is the board's rules, our rules, I should say. And there's no one is trying to do anything outside of what you may want the final product that you're going to come up with. So if someone doesn't want to do this, then make the motion that is taken off and see what other board members say about it. And then if that doesn't go pass, then we debate what's in front of us and move on. Otherwise, we're going to continue to do this until that we call.
Okay, so my whole line of conversation here is in regard to page 1 in terms of what's being crossed out. That's part of what we're doing today. And the reason I asked you about when the rule was drafted is because it's so close to when the statute was passed. That is, our own rule is good evidence of legislative intent that the primacy, that when we suggest the primacy comes out of precisely because it was drafted in conjunction with the statute. So when you're looking for intent, the timing of the rule plays a factor also. So I'm not really understanding where this other intent is coming from, to ignore police. And as a matter of policy,
It's not to ignore these, it's to include, right? People who are not on the list, right?
but the effect is to nullify any real significance of a lease and to actually nullify the value of the holder of the lease. And if this is such an important issue, why is the city not offering to compensate the victims who are going to lose from your proposal?
Privacy.
Yeah.
So here,
The owners.
Can we not go to compensation?
yeah, I need to take part of the point. So here's the thing: if we're going to move forward, we need someone to make a motion as to where we go from here.
Let's get a consensus first, no?
Consensus of what? And we're not going to get a consensus.
Of whether we want to leave the rule alone and whether or not we want to pursue the most extreme option, which is what's on the table.
So there could be a motion to not change the rule. That could be a motion, and there would be a vote on that. I don't know, I'm not sure what consensus
Well,
would be.
That sounds like your emotion.
Well, no, you're asking for a sense of the discussion, and I think that's very good. All right, well, let's commit ourselves before a motion is made in the vote.
My position is that it should change, but I sense that, some board members want at least some small changes, some want many more. But if there's a consensus of those who just want small change, maybe that's where we're going.
So I'm sorry. Go ahead.
No, I was just going to say, so, Robert, if that's true what you said, then perhaps the chairman would even be happy with a motion that says that we would like to have multiple options brought back before us.
So this is a motion that I can't make a motion. I cannot. I understand. But this is what we need to do, is that there needs to be a motion whether or not we go forward with two options. One is not doing anything, which is, that means debate be done on this piece, or debate the rules in front of us. Do I have a motion? Mr. Chapman?
I make a motion that we consider changes in order to review how to protect those who are not on lease. And start with the language that is in front of us.
Does everyone agree with the motion? Do I have a second?
Would you repeat that?
My motion is that we consider how to protect occupants who are not on leases and start by looking at the language drafted in front of us.
I'll second that motion.
Thank you. Mr. Roche, you get a second. Mr. Ruda.
Ms. Torres.
You want to debate it? I'm sorry.
Do you have debate on that?
Pardon? I'm sorry, yes.
You wanna
Does anyone have any comments?
Yeah, I'd like to.
I was so anxious to go.
I'm inclined to either vote no or abstain simply because we jump to the protected occupant piece because it is so intriguing and there are so many permutations, and to have my esteemed colleague, Mr. Carver, looking out for the rights of those prime tenants. I'm, you know, I appreciate that. The problem is, part of what's in the proposal on the floor with regard to the way that the board has, through questioning that originated not by the board, to be perfectly honest, but by the former executive director, dragged primary residents into oath hearings in a way that has become so pernicious that I'm really hard pressed to vote in favor of debating this draft, which contains such a ruthless approach to primary residents.
So isn't that what we're about to debate? Isn't that what the debate is all about? But it is, wait, I'm just,
I'm just stating,
I respect everybody's opinion, but isn't that, the option of leaving it alone and doing nothing isn't doing anything to help the tenants.
well,
At least we're making some sort of a thing that we're going to somehow try to agree that we're going to battle forward with something in an effort to help the tenants.
in my opinion, this draft that we have before us is attempting to do the impossible in the sense of trying to chase two rabbits at once. The primary residence provision that's been worked into this is over this sequence of cases as they've evolved basically since 2014 to 2018 really should be looked at separately. They're two very distinct and very different issues.
Okay, so
so
I guess I'm
Mr. Borges, I thought you would have corrected by now the fact that we are off topic in this motion, correct?
No.
How is that?
No, we're discussing the motions.
We have,
I mean, we
we
can't
have one,
take a second motion on top of
we have
the
a
motion
motion.
that's on the table. But we can certainly discuss this until we call the question.
Mr. Torres, yes.
No, I don't, I'm just trying to understand, Chuck. I like that primary residence hasn't come up yet, that we separated it out from the discussion of prime, leasing, and sub, right? So is the motion on the table that we would work to help resolve what we're seeing as an issue that needs work, so that we're more in keeping with what tenants need? But that motion has nothing to do with primary residency at this point, right? We haven't talked about that.
Well, it's in here. You'd have to ask the maker of the motion for this.
Okay, can you clarify on the motion if it has anything to do with primary residency?
I think at this point, we're having a debate about the language drafted, which is then have been folded into whether we'll have a debate about the language drafted. I mean, I'm happy, we can adjourn and leave it as is,
I understand.
you know, but my sense was that the majority of the board has a concern that there are occupants in these units that are not currently being protected in the rule as it is currently situated. And therefore, to try to address that outstanding need, the staff have drafted this language. Now, whether this language involves 2 or more rabbits, I don't know. However, that's the idea. If the idea is that we're not concerned about those, if I'm, you know, that people are not concerned about those other residents who are not on the leases, and that the rule as it currently is situated is fine, then I think we should not waste our time looking at this language. But debating about whether the language is worth debating about does seem to start to get a little bit bizarre.
Your motion, as I took it and seconded it, was simply that we are going to agree as a board, if it passes, that this is our baseline, and that we are going to work from this and craft it and mold it in a way that we feel is beneficial to update, as Mr. Bearwood said earlier, something that we need to update for the sake of the changes that have occurred.
That's how I understood it.
Et cetera, et cetera.
Did anyone understand
So
otherwise?
I'm sort of repeating that just so I'm clear in my own head, but I still feel that there's nothing about your motion or the motion that I second that is hurting us, hurting the tenants. It's just saying that here's our baseline, what the staff has crafted, and we're going to mold that and shape that and form that to try to bring it more into the current age and the current society.
And either we like it or we don't like it, or we want changes or we don't want changes, or whatever. But the idea is that there's a consensus that there's a need which is not currently addressed, and we'd like to try to address that need. Now, you say, I don't agree. You know, we should stick with the current rule, that the focus is on people who are signatories to the leases, because those are contractual arrangements, then that's fine. That's the position, and we should, you know, there's no point in trying to consider changes.
If that's the case.
I mean, I guess where I'm hesitant is that it seems like the draft is potentially making it a lot worse where it stands right now, so I don't want to go backwards.
Well,
And
then you would want to talk about the draft rather than,
so by accepting talking about the draft, I'm not accepting.
you're not voting on
I'm
it.
not.
Yeah, it is actually what it's called, a draft.
It's a draft for discussion, but if you, look, either everything is perfect the way it currently is, and we love it, and we're gonna stick with it, or we're gonna consider a change. And if we're gonna consider a change, we can start by talking this afternoon. So either we're ready to make, you know, think about whether it's worth doing something, or we're thrilled with the way it is, and I can go back to my office and catch up on all the emails finally. So what are we doing?
Thank you. Mr. Barrett.
Ms. Torres?
Have to say yes or no?
Yes.
Oh, you changed the order, I'm usually.
Yes. Yes.
Yes.
Mr. Cover?
No.
Mr. Barrett?
Yes.
Mr. Roach?
Yes.
Mr. Hernandez?
Yes.
Mr. Delane?
Abstain.
Mr. Chapman?
Yes.
Chairperson Hilton?
Yes.
6 in favor, 1 against, and 1 abstain.
Thank you. Thank you, board members. I appreciate the debate, and let's get to something. I appreciate it, thank you. Yes, Mr.
Mr.
Wilson.
Chairman, is it possible that we take a...
Yes, actually, that's a good idea. If you could just take a 5-minute break. Thank you. We're back on the record. And I just want to advise the board members that my sound engineers ask that you hold your mics when you speak so that we don't have a problem on the recording. So back to Ms. Wilson.
So if I think since we spent a lot of time already discussing the concept of primacy versus not primacy, we should start with the new B2, which is very broad. It says a person is a protected occupant if an owner or responsible party is the person on a registration or otherwise represents the law for that the person is a protected occupant or the law court issues an order determining the person is a protected occupant. I think that would probably be the place where we would want to insert more requirements, I guess, if we want to limit it. So, I think it's up to the board to figure out how you want to limit it and what we should put in there. Bearing in mind that the law department will examine it for constitutional issues, such as equal protection.
Thank you, Mr. Carter. You have the mic, so I assume you...
I had a question about that language that you read. That's not your issue, though. So you have owner or responsible party.
Yeah.
And the recollection is the definition of responsible party. I think it's a little too broad here because I believe that it would enable a lessee to register
And that, let's see.
No,
Oh, yeah. Oh.
and I don't know that that's your intent.
Right.
I think it's something that you can go back and look at. I had suggested owner or other holder of the owner's interest. At some point that was in there, but it seems to have not made it here today.
That's a good point.
What about designee or something?
Well, sometimes it's by operation of law that someone holds the owner's interest, so the owner may not be the one who actually granted it, or something to be,
Registered.
yeah, something to be looked at.
Okay.
So can we look at or we decided?
No, I think that is correct. We need to fix that language. We'll have to figure out.
What
how
are
to
we
fix it.
taking his word then? When you say...
So I said owner or holder of the owner's interest. I don't know that that's the best solution, but I'm just throwing it out there for the staff to look at a little further. It's an important point and it's highly technical, so I think it's worth some private study on the staff's part.
Yeah, I agree with that. That's correct.
Now, Elaine, so the issue that you just raised, that when you said other factors just now that you're seeking from the board, so you're looking for factors more than just mere occupancy? Is that what you're asking?
I don't know. I mean, I think that if there seems to be an issue that this is too broad, and if this is too broad, then it has to be limited, and we have to figure out how to limit it, and I'm open to suggestions as to how to limit it.
I understand that. I think the non-lawyers on the board may not entirely follow what the statute is doing here. So just to be clear, this is saying in essence, mere occupancy on the magic date is enough. Yes.
Well, are you talking about two?
I'm sorry, I had jumped to 3 already, I guess.
Yeah,
Oh, we're not three.
we're just at the very, all we've got was,
Just understood.
we've been here over 2 hours, and we've gotten to 2 little I and little I.
But again, the conversation that we had in 90 minutes is...
I don't want to talk about it again.
All right.
We had 90 minutes, okay?
It's directly on point to the issues coming up.
I understand, but we have only gotten as far as 2 little I.
So, Elaine, why is this, I'm just not following why little 2 is an issue if the substance is occurring later in the statute. I'm not quite understanding what you're seeking here up in 2. Because little 2 sub 2 is a reference to elsewhere as to what,
Okay, yeah, I see what you're saying, yeah. So I guess we are on 3, actually, unless anybody has a problem with 2I, other than the responsible party part, yeah.
At some point, I'd like the staff to explain 1.
A natural person, is there
Yes.
people that were corporations or partnerships or whatever that wanted to be protected?
Right. And if the lease is in the name of an entity, a commercial entity, an artistic organization, how would that play out in the rest of this as you propose it?
I mean,
I think it would be, I think that whoever is the signatory, assuming that this is a lease, that whoever is the signator on the lease would be the natural person who would be the protected occupant.
signature or the principal?
Well, I don't know.
Chuck, can you give us a scenario?
Sure.
I think I'm following.
If you
Yeah,
go
I guess
back
that is-
and look at law board cases, you'll find that lots of times, in addition to other ways that the occupants, the residential occupants who should be qualified for protection, got around to the mutual satisfaction of the tenant and the landlord, that the space was not being used for residential purposes. The lease may have been between the landlord and an arts organization, a dance troupe. There's a case where it's a church, so that how you then sort out who the protected occupants are. If the only lease that ever existed was between whatever entity the landlord is and some kind of corporation or DBA or LLC, that has been an issue in the past.
So just to clarify, I'm one of those young lawyers. If there's a corporation, I guess, or LLC, or something like that, where there are more than one principals, I suppose, right? Is that your question as to
Could be.
who then would be that individual?
The main concern I'm expressing here is, as we see, one can have a significant discussion. In this case, I think Mr. Carver's argument is not correct, but in the law, sometimes it says tenant, sometimes it says occupant. What does it mean? I would hate to see putting natural person in creating some other argument that is perhaps off target, and somehow we've gotten through 35 years without needing to define protected occupant as a natural person. So I was just curious what was the need that caused that to come up.
Because at the end of the process, the lease isn't going to go to the corporation. The lease is going to go to a tenant, a real person. The housing maintenance standards apply to real people, not to corporations. A corporation isn't freezing. The person who's in there is freezing if there's no heat, not the corporation. So that's why.
Well, when you say at the end of the process, you mean after go?
Yeah, after legalization.
Right, so if it's an issue for removal, I'm not sure why it becomes part of the definition of protected occupant.
No, I said that you asked me for reasons, that was a reason I gave. I gave you another reason also.
But wouldn't the corporation have officers that are listed as the officers of a corporation, wouldn't that turn a corporation or an LLC or a business into a person?
No.
The Supreme Court turned corporations into people.
Right.
They're separate entities, but they're not, they're separate legal entities, but they're not.
Under the rules as proposed, a lease has no meaning anymore in this context. So I'm not sure why it would matter if a lease were in the name of an entity instead of a person. So I don't think there's a problem with natural person being.
So, yeah, and let me just ask for my own clarification here too, is what if the entity changed the principles of the corporation? What happened?
Yeah, that was my Right, that was my question. If the lease is with Acme and the Roadrunner leaves and is no longer living there, and instead we have another occupant, I mean, the idea, the focus should be on who was actually living during the appropriate time, not the corporate structure of the
Correct.
entity. So,
Do we need clarification?
That's up to the board.
Are you advocating maybe we should just add that to that and not just leave it off at natural person, but give it some sort of additional definition?
Why this was in here in the first place struck me as something I didn't understand, so I asked. Now that I've got some kind of answer, I'll give it some thought. But I'm just concerned that we put things in and later they come back to bite somebody who, for reasons that we had no idea that was what was going to happen.
No, I was just wondering back to his question, but not with corporation. I mean, what if you just got rid of natural? What is natural?
So person could be defined as also other entities, partnerships, etc. So a natural person is a human being.
So the word individual doesn't substitute? Or the correct occupation should be an individual?
Natural person is the accepted legal term. So,
All right. Okay, is everybody clear on that? I mean, I know you gotta give some thought, but can we move on as?
If we said persons and persons, would that do it?
that's without natural.
Without natural?
Is anyone against the natural word? Is there a reason why we're
Is it,
against?
Well, I'm just asking that.
Chuck pointed
No,
out.
you're not
Yeah, but
No,
because,
you're not a lawyer. That's
because part of the mission was to simplify the language and make it understandable for the public. So I personally don't understand the natural part, and then I start thinking, are you kind of a citizen or someone who's not a citizen?
So we have to find person in chapter 1, okay? And the definition of person in chapter 1 is an individual, partnership, corporation, or other legal entity, and any individual or entity acting in a fiduciary or representative capacity. Okay, so the word person itself includes other kinds of entities that are made up of human beings but are not in and of themselves human beings. And the idea here was to ensure that the people that what's being protected is a human being, because those are the important things. Those, it's the people that are going to freeze. You wouldn't want somebody who is there and should otherwise be protected. You wouldn't want a landlord to come back and say, oh, but you are not an officer of the corporation, so I don't have to provide heat for you. I mean, that makes no sense. So we were concerned, we as the staff were concerned that we wanted to protect human beings, and the legal term for that is natural person.
But, and if we take out natural,
Well, then we get to the
No.
definition of person, we would have to change the definition of person in chapter 1, and I don't think we want to do that, because there are times where we use the word person where we want to encompass corporations and partnerships, et cetera.
To get to what Chuck was mentioning, I mean, even if you're in an office, you care about people. You know, like, even if it is an entity, and you still want, I'm just trying to, I don't know. I just don't want to exclude anyone, we're trying to include more people.
Yeah.
We're trying to include people,
Yeah.
People, not,
natural.
I get it, yeah. So person is defined, so natural person, make it more clear that we're talking about individuals.
Doesn't-
No,
I don't see where this-
Wait a minute. Who's talking?
Excuse me. I don't see what you say makes much sort of sense to those of us that are not lawyers. To say natural is more important than just saying person.
But person is a term that's defined in rules. So if we just said person, it would include corporate entities and partnerships, and legal people that are not living, breathing human beings. I can't believe we're having this discussion, I'm sorry.
But aren't we talking about, and maybe I'm not following, aren't we talking about more inclusion? So
Yes.
if you use the word natural person, we're not talking about more inclusion, we're talking about particularly one individual.
Person is fine.
We can say
We
person
say-
or
we
person.
can say
You're
person or
right,
person.
we are excluding non-humans. We are requiring that the people who are going to be protected are people. So it can't be Acme. So it can't be a problem where we come up, where the owner says, I have a lease with Acme, and you have been living there, but you are not Acme. And therefore, you are not protected. So that the focus is on actually protecting people.
So it could say person, natural person or persons.
Oh, of course.
Yes,
So
absolutely.
that's what I said.
Oh, yes, of course, yes.
When I said
Yes.
that, and
Yes.
Mr.
Yes.
Farmer said no.
That is fine, yes. Thank you.
Okay, you're still saying no?
Already done. Mr. Carver, you have the mic.
I would rather talk about legislative intent, but we're going to talk about singular and plural. So the reason is simply a singular person is because it's a protected occupant. Singular is a person. It doesn't preclude having multiple protected occupants. So as is drafted by the staff is fine.
So maybe we should say protected occupants registered with the law board must be
Natural.
natural persons.
No, it's everything is singular. That's the connection that's going on here. Applicant, owner, I mean, this
Even when it doesn't make sense.
No, we could put after occupant, we could put an S in parentheses, and after person, we could put an S in parentheses. I think that would solve the issue.
Okay.
So that's what I'm going to do.
Mr. Renee?
Yes, it strikes
Mike,
me.
Mike.
Come on.
It strikes me that so far, all I've heard is hypothesis about how this could be a problem down the line. I don't think this is an issue that's ever been a problem to date. I am concerned that there's enough treachery in this rule as it is, so I would like to make a motion to strike number 1 from the proposed draft.
Sorry, what is that? The motion is from Mr. Renee is to strike number 1 and eliminate it from the proposed draft. Is there a second? There's no second.
Wait, I guess I would second that. I mean, if it's confusing language, I'm just trying to,
It's not confusing language, I don't think. It's-
Well, we make
Mr.
motions, we
Mr.
can't
Delaney
talk
is
about
saying
it.
that it is not necessary because there's not, what do you call that? What do you call that? There's enough what in the language? Treasurer.
Can I just say that I resent the use of the term treachery, that we had to start somewhere, and that this was put out there as a proposal with the intent that the board would have strong opinions and want it to be changed. So there is no treachery involved. We are trying to be transparent. It's what we think it should be, but if you don't want it, that's fine too, and you should advocate for that, and we will change it as you see fit. Thank you.
I guess I would second, sorry. I would second it if it's redundant. I mean, it does seem like a very vague statement. Protected occupant. Must be an occupant. I mean, is it so obvious?
No, it's not saying it's
No,
redundant.
because people have tried to register protected occupants as corporations, so it's not redundant. It was what we felt was necessary.
To protect against corporations, even though Chuck's mentioning stories with artists and
No,
institutions.
Chuck's saying that it's not an issue. I think that's what I'm hearing, right?
Chuck's right here, and what you're going to say is, to my knowledge, this has never come to the board. If there are people trying to register the XYZ Corp as a protected occupant, that's news to me, but I guess those have been dealt with on an administrative level.
Right, and that's why she put it in. But, you know.
Staff.
I'm sorry. Everybody's jumping. But here's the thing. I don't see a problem in putting anticipated problems inside the budget to make it very clear. I mean, I don't see a problem with that, but there's a motion on the board and there's a second. There's a discussion.
Just to clarify, we do have a motion in a second?
Yes.
And now we're looking for
We're in
discussion.
discussion.
So I would like to have, I respect the fact that legal minds put it in there, and I believe there's probably a reason for that. And I would really appreciate if I could know that, understand that reason. So with that, if Colleen could, if Paulson could give us the legal reason why we should have that in there, that's important for me to be able to vote for it.
Because staff is concerned that if the corporation is a protected occupant, then the humans would not be protected. That's the reason. And the protected, if you look at the rules, particularly the housing maintenance rules, they're there to protect humans and I think not corporations. So, you know, I don't want anybody to freeze and have a landlord say, but they're not protected, so I don't have to do anything about that.
Any other discussion on this? Ms. Rivera?
Ms. Torres?
What's that one where you can like remove your second?
Abstain.
You want to remove your second?
Oh, you want to withdraw the vote?
Yeah.
Oh. Mr. Bowers, I'm going to have to defer to you on how to proceed.
There's a motion and a second, and it has to go forward.
He has to go forward.
Okay.
And is the person who made this second able to vote against the motion?
Yes.
Okay, then we vote.
Ms. Torres?
If you're withdrawing it, then you have to vote against it.
Okay.
No, you should vote against it. No.
No, she's.
You can second the motion just to put it on the floor for discussion, and then if you see that you want to vote against it, you're perfectly capable.
You could actually have heard the
According to Robert's rules, you could probably, you know, no if you want. Or yes.
So just to remind everybody, the motion is to strike number one. That's the motion. So we're going to leave it in or we're going to take it out. So the motion is to take it out. So if you vote yes, you're voting to take it out. If you vote no, it's going to stay.
Well, it still be changed, though, we didn't vote.
Oh, you want to continue discussion with this?
Well, the motion is to leave it open.
Wait.
The motion was to strike it, so
Right.
if you want to leave it in, you vote no for the motion.
Yeah,
Sorry.
That's okay.
right. So if you want to do something else, let's finish this motion and then you make another
Okay.
one.
Mr. Shachter and I recommend, as does your legal staff, that you vote no. We need this sentence.
Is that a comment on the motion? We're in the middle of it.
Yes. Comments, yes.
Mr. Rivera?
Ms. Torres, No, but I want further discussion.
Just now.
Okay, no,
No.
Mr. Roberts,
No.
Mr. Vogt,
No.
Mr. Hernandez,
No.
Mr. Delaney,
Yes.
Mr. Shacker,
No.
Chairperson Hudson.
No. Motion's not passed, thank you, but I think you have a motion, a new motion on the table do you have a motion to change, to make amendments to this, not strike it, correct? Is that what I'm getting?
Yeah, I want to get to the right language, but I can't tell when we're discussing, I don't know when it is, but I can't tell when we're discussing here, are we like
All this means is that we're back to square one with this, and if you want to make changes here.
Okay, because actually, I prefer to, even all of this, to just like read it through and understand it, like what you're saying, before I can decide on like one piece of it.
Well, we haven't adopted anything, right?
That's correct.
Right, so therefore, there have been no commitments made on any line other than the fact that we haven't gotten rid of it.
Well, we got rid of, we've decided, you've decided to change the old language in some way. That has been decided.
Me.
Yeah, or at least to have a discussion about
Yes.
that. Yeah, okay.
We don't have any motions on the floor. But we have a desire to modify number one. Chuck, do you have any thoughts? You're just flat out, you just don't want it there. You don't have any thoughts as how we could change it to make it.
Does anybody have any thoughts on changing it? Does anybody want to amend it?
Mr. Chairman, can I make a motion that we task the staff with coming back with an alternative to number one?
I would need guidance from the board, I'm sorry.
Okay, I'm just looking for some.
Yeah, no, I understand, but I would need guidance from the
So,
board as to what you
between
want to
these
say.
different motions, what I'm getting at is that we don't see anything necessarily wrong with keeping number one there, except Julie may want to have a second look to see if you want to modify that for some, in some way. Add something to clarify or take something out.
Right, I think we talked about S's and occupant S.
Yeah, but that's, your staff can fix that, right? Would you like us to move on and just let staff come back with a fix to number one? With the S's?
Yes, and I guess I want what Chuck's bringing up is and what you're saying with your own case load that we don't know about. If you're running into, where it's an issue that there's corporations interfering, if we know more about that, we can make more informed
Sure.
decisions.
And I just want to remind everyone that we're not voting on the final rule. We're voting on moving, and making changes that make sense right now, and then everything will be, again, put back into all the change, and then you'll have a good look at this again. So it's not going to be final today. I think it's fine. All right. We have to go?
Yes, we had a quorum, so it's fine.
Okay. All right. So, number three, I think.
Well, so we had a comment on 2I, so now we're on 2II, which leads us into number 3. So, let's put aside primary residence for a moment and just stick with the idea of spouses, roommates, etc. We'll get, I promise you, Mr. Delaney, we will get there, and I know you're going to want changes, and I assume that the board will change. We'll change it. But for now, since we have spent all of this time talking on this concept, spouses, roommates, etc., I would appreciate input from the board as to what we should add to this, how we should change it to figure out who to add.
If I might.
Yeah.
If I take it what you're saying is you'd like to go into either who we would cover under 3 or what the indicia that we would look at.
Yes.
And I'm happy to hear what the board thinks. I'd be interested in what the staff thinks. I just want to reserve the fact that with number 2, where we have the division between number 1, which says anyone, the owner or responsible party or whatever we might come up with, lists as a protected occupant. In its interplay with number 2, where the board issues an order, is an issue I've stressed in dissenting opinions in the board meetings previously, because basically this lays the groundwork for really bringing back what used to be known in the 1960s and 70s as a key fee. A key fee. Oh,
K-E-Y?
key fee, yeah. Oh, you want to be a protected occupant? I'm a landlord. I'll be happy to make a protected occupant. All I want is consideration for that. So, in my opinion, to have a system whereby if the tenant has to apply for coverage, there's one set of criteria and one qualification versus an owner can register anybody that the owner wants to, is part of what I consider not a good thing. Try to use milder language.
So,
We can come back to that. I'd love to hear what
no,
you...
we don't know. We don't have to come back to it. I think it's an interesting point. So, you would be in favor of saying a person is a protected occupant if, and then listing stuff without the separation between the registration and the findings by the board?
Since the board went, in my mind, into the wrong pathway, starting in 2014 with Belgium, and we've seen this. We've seen cases where a couple of times cases didn't pass, they came back, and it was okay because the landlord had registered the tenant, the same tenant that we would not afford protected occupant status.
I don't think that's true.
I think PAC is one.
PAC was a remand, and then the owner registered.
Right.
But it was a remand. It wasn't that the board said that Ms. Pack's niece could not be the protected occupant. The board remanded to go to oath to have that, to get facts on that issue.
The board remanded because of all these new criteria that have been put in place.
Criteria as in eligibility criteria for coverage for a unit, or criteria as in?
I'd have to reread PAC before I could give you a definitive answer on that.
So the issue was whether or not they had, there was a husband and wife, and then there was a niece, and the issue was whether or not the husband and wife had moved to Maine, and the niece remained in the unit, and that was the question, was whether or not it was their primary residence. It was remanded for that, and then after that, the owner registered the niece.
Right.
But it was never a fact
in my opinion, the remand on the issue of primary residence was inappropriate because I don't think primary residence has anything to do with determining who's a protected occupant.
So, coming back to this rule, do you think that we shouldn't have 2I and II, and that we should just get rid of the I and the II? I mean,
Well, we have to better understand what the implication of that is. We have to understand now how it works when people are cooperating with each other on this issue. What happens now?
so if an owner comes in and voluntarily registers, then we usually name whoever the owner names as the occupant on the unit, we put in as the protected occupant unless there's some sort of contest by somebody. The registration is an application, it's supposed to be mailed to everybody in the building, so people have a right to contest that. That's pretty much how it works now. I think that's
So, and I
that's a
think
good question.
your intent with the language is to keep the status quo on it, yes?
Yes.
Yes. Have you experienced any problems with the status quo?
To the extent that owners down the road, when we were removing properties, were not happy that people who had been named on the initial registration were considered protected occupants, yes, we have had problems with that, but the board clearly ruled just a couple of months ago that those people are protected occupants. And plus, in that case, we also have an order, the court said, finding that that person was a protected occupant. So owners have contested that.
The last half of that prior.
In that particular case where the owner was bringing it up, it was also a board order that had found that it was a daughter who was the protected occupant. But it has always been the local board policy that whoever they listed, that's who we name as the protected occupant.
Okay, and then.
So owners are not happy about that.
Okay, and at the moment, it's a policy, it's in our case law, but it's not in a rule. This is codifying
Yes,
that case of.
Yes.
Case of policy.
yes.
Were the owners on notice of the implication of listing the applicant on the registration?
I can't really answer that because it was a different owner from the original owner.
Right.
So
Well, I mean, I guess in their diligence in the purchase, it's public record, and it could have been found. couldn't it?
and certainly they could ask who in the, at least who in our records is
Yeah.
listed as part of that.
I mean, is this the common understanding of everyone, that once you're on there, once the owner writes you in, you're rich?
So again, Martha is not here.
Right.
So, she's my institutional knowledge. I'm only here 2 years.
Yeah.
But yes, that is my understanding, that is the understanding. That's how it works. That's,
All right, so it's something, I think, this one is something that I'd like to think about for next time. We'll move on.
okay. Which brings us back to 3. So,
All right, so this is an extension of the one conversation that I was having earlier, and it was not meant to make the meeting longer. I was getting to the substance.
I'm fine.
You have no problem, okay. So as drafted, mere occupancy is enough to get the status.
Yes, I think that was our intent.
So this draws in everyone, roommates, boarders, lodgers, whatever those terms mean.
That is in fact the proposal, and if the board wants to limit that, tell us how you want to limit it, and we'll write it.
Okay. This includes the adult child who won't leave. It includes Aunt Fran, who is home, who lost her home and was staying with her niece on the effective date of the law. This is just mere occupancy. So as I said before, this is a tremendous upheaval in the status quo. It absolutely wipes out the value of the tenancy of the parental lessee. And I'm really serious when I ask, why isn't the city willing to pay for that loss? If this is so important, why isn't this cost, shifted to all the taxpayers? Why is it falling on the parental lessees and the owners who would have tremendous negative economic consequences?
So I think it's an interesting issue. It is not within the authority of the Loft Board to award owners or prime lessees any kind of monetary awards. Like the Loft Board does not have that authority under the law to do that. So I think it's a moot point to discuss here.
So you're telling me you have the authority to wipe the value out, but not compensate for it. I guess it's
board has the authority to determine who is and isn't a protected occupant, to make a rule as to who is and isn't a protected occupant. That's not the same as compensating people for different things, you know, we just don't have that authority.
Well, I mention only because we're making a change to existing status quo, right? So,
Right.
That's a little different from, in the first instance, establishing an illogical tax, as opposed to this. I mean, this is affecting real live owners and real live premises. So we had a whole, you know, I don't know that that's the case, that the city is incapable is legally incapable of compensating for loss.
I didn't say the city wasn't, I said the Loft board doesn't have the authority to. There's a difference.
Okay. Well, if it doesn't, well, if it can be done, why isn't that part of not necessarily to us, but to whoever needs to do that?
We're talking about rules that the Loft board can pass. That's what we're talking about. This is an issue that's totally outside a proposed rule, right? And if somebody wants to bring a lawsuit saying that the city passed this rule and it's going to cost you $5 million, then go for it, file your notice of claim and go for it if that's what you want to do, fine. But that's not this rule. That's not within the purview of this rule. And if the board tried to pass a rule that said, we're changing the protected occupancy rule, we're going to include all of these other people, and everybody's going to get X amount of dollars, anybody who's a prime lessee and owner is going to get X amount of dollars, the law department is never going to sign off on that. So that's, you know, why are we even talking about it? It's just not within the authority. It would be so ultra-virus. Is there such a thing as so ultra-virus, or is it just ultra-virus or not?
I mean, frankly, I think that's a reason to keep the rule as is, to enable prime lessees to exclude all of it. But this is where we had asked for options. You know, we had options on the table. I think this is the time for you to bring back the options and for us to talk about which make sense and which don't. Because the inclusion of boarders and roommates and the adult children won't leave and Aunt Fran creates an enormous economic impact on owners and on prime lessees. We previously indicated that we had a problem with something so extreme. And again, it wasn't just me. This was a vote of the whole board to look at options. And if you think it's unwieldy, let's just limit it right here in this paragraph to who would be counted. And you could go back to the language that you had in the past. You could maybe have a list and board members who want to include more people, not me, but the others, and then they could talk amongst themselves as to who would merit the status at the expense of the city.
It's been a long time since this first law went into effect. I'm not sure what was going on in the minds of the legislators that initially passed this thing, but it's always been my sense is to simply provide housing for lots of people in the city of New York that were living in conditions that were not really legal and feasible in order to keep those people there. I hate to use the word artist there, because that was the first impetus to get this law in place. Now, as things have come by, I understood that 3 or 4 years ago, the vacancy rate in New York City was 2.8, which included new units that hadn't been rented yet. So there's essentially no vacancy in the city of New York. there are other things that the city could have done to help the vacancies, to increase vacancies of a lot of buildings that are all over Brooklyn and Queens that are in deteriorating condition. The fact is that we want to provide housing, living conditions for as many people as possible to keep New York the way it is, a sort of dynamic entity. So that's my bottom line on this.
I appreciate those thoughts, but the question is, why should the prime lessees have to pay for it? And the city wants to give others housing. The city can give them housing. Why is it coming out of the pocket of the prime lessees and the owners? That's the ultimate problem with the proposal.
Isn't that for them to figure out on their own, like a couple would figure out who's paying what share of rent? I feel like that's in their own world of what they figure out, not us.
No, I'm not talking about the operating expense or the rent. I'm talking about the value, say hypothetically, the value of the premises is $1 million. I'm using $1 million only because that's a figure that we put in a letter to the bankruptcy court, talking about how valuable these units may be. Suddenly, a prime lessee who had a property just worth $1 million now has always had a roommate, but with the passage of this law, the roommate now has equal rights to the unit to stay forever. So the $1 million value is now, maybe half that with the one other person given equal legal standing has lost half its value, or maybe more than that. You throw on the adult child who won't leave, and the roommate, now you've got 3 with equal status. That $1 million value is now being shared by 3 people. So you divested the primacy of all that value. That's what I think is struggling.
I'm sorry, you mentioned a letter to bankruptcy court with $1 million value. I'm not familiar with what you're...
This was the case. I reported the case, and the bankruptcy court asked the staff for a letter about sales of rights. And one of the things that we wrote in the letter is that we had seen a sale of $1 million.
Oh, I'm sorry, I missed that. It's a very interesting case. I'd like to request a copy of the letter.
Sure. Public record.
I think it was part of the record of the case. I had asked to look at it, but it actually might have been sent to everyone.
It may have.
I don't recall. Yeah.
Usually if one person
He's
asks,
just
it
saying,
to everybody.
he's just saying he didn't see it, he sent it.
Actually, if you recall, last meeting...
Can we stay on topic?
Actually, I would like us to move along. I mean, we're going to get, I'm sorry to doing this, but we have less than a half an hour. Actually, we have 20 minutes. This possible.
So, I guess we're back to, so if I understand correctly, you want us to come up with some sort of a list or some sort of a definition that Mr. Carter and everybody else would encompass more people, but not necessarily everybody.
Well, we had previously asked that before.
Right.
So
Right.
all I'm really doing is asking you to do what we've already asked for.
So I do want to go back to the law department who had raised some concerns back whenever it was that we talked about it, and we had all of those options. So I will go back to them and resurrect the options and come up with something that I think will pass muster. with the law, at least with the law department. Because let's face it, if they're not gonna sign off on it, what good is it having it? So,
I'm trying to be difficult, but.
no, I think that's good.
If you want something to be done, I think you gotta give us the broadest possible choices, and those choices.
I thought I gave you the broadest possible choice. Isn't this the broadest possible choice? You're saying, I don't like that, I want something more narrow, and I'm saying, well, how do you want it narrow?
It's plural, the choices, that's what it is. I think that would be the most useful path.
Can I just ask a question, Mr. Hopper? So if you had 4 or 6 choices on the table, right, how would we get to debate 6 choices before we start debating the chosen of the 6?
So who on the list is going to make it in, is going to qualify? You know, everyone seems to want to add spouses. All right, add spouses. Roommates, boarders, and friends. You know, those people in
I
the...
refuse to write Anne Frank.
All right, thanks.
And Fred Pye?
In Frank or in Frank?
All right, okay, I appreciate taking the time for this one.
Okay, then I guess we should start talking about primary residence.
There has a way for that to...
No.
I actually have a question on number 3. Number 3, II, whether the IMD unit contains the applicant's furniture, clothing, and other personal effects. I have no issue with that, but I'd like a little help with clarification on what exactly would qualify as clothing and personal effects. Would that mean if I could somehow prove I had a shirt hanging in a closet, IMD, would that be enough for clothing? Or I'm just trying to understand.
So this is a list of factors to be taken into consideration.
Okay.
They can weigh one way or the other, right? So would you be more inclined to find that somebody lives there if they have no furniture and clothing there? Right? Wouldn't you think that somebody who lives in a place has furniture and clothing there? On the other hand, we have a case where, well, I can't talk about this because there's an appeal.
Well, I understand the furniture is kind of substantial, but, and I'm not opposed to this, I'm just trying to understand what would quantify as personal effects. If I said, oh, well, if you check on the bookshelf, you'll find a book that says that it's the property of Mr. Roach. In other words, what you're saying, the law would make that determination, is that
it's an issue
enough?
of fact.
That's not enough. I don't, you're...
Well, this is what I'm trying to
But
say.
that would be something to be considered, right? In addition to other things.
Okay, I just like I said, I'm going to try to understand.
And these were these are factors that were taken from cases that
Okay,
were decided.
Initially, when lofts were illegal, that was not the determination. The
What?
determination whether they're living there is whether there was a bed. And some loft dwellers at the time had these beds that would lift up to the ceiling. So an inspector would come and see that they're not really living there, although they could have a bathroom and a kitchen and clothes. So now we turn this thing around 180 degrees by saying you only need furnishing there. And I don't see what's wrong with that. You know, considering at one point that you needed a bed. Now you don't even need a bed.
Well, first of all, not
You know,
every-
I mean, I think that that 2 and 3 seem to be a little silly. You know, bank statements, you know, you can get a bank statement mailed anywhere you like if you want.
Okay.
I think we have to be a little more careful.
None of these
about-
by themselves these are factors to be considered.
I just want to.
I mean, most people have
I
their
don't
bank
have a
statement
problem
mailed
with that.
to their residence, to their primary residence, most people. These are the things to be considered. Yes, go ahead, I'm sorry.
No, I'm sorry, Mr. Chairman. Again, I just want to clarify, I just want to understand a little bit about what they were talking about. I'm good with it.
You know, when we were drafting this, we said, well, you know, has come out of the cases, with the exception of attending a local school. I put that in. But, you know, for the 1, 2, and 3, these are factors that the board has considered in cases. So here we're ratifying some of those factors, but we're qualifying it by saying no one factor is determinative. It could be that people are not having their bank statements mailed to their house because they have no mailboxes, the mailboxes are broken into, whatever, so they have a P.O. box. But if there's going to be a trial and somebody's going to be testifying to that, then that's a reasonable explanation. If they're found credible, then why would the board say no? So I think that's where 1, 2, and 3 came from. That's where those factors came from. I misnumbered it.
Did they also come from, did you look at the red guidelines board?
The Red Guidelines Board has a lot of other factors that we felt probably wouldn't apply, and in cases that we've had over the years were problematic, like the 183-day rule, and the tax returns, etc. So we didn't want to necessarily list those, although people do actually submit tax returns as parts of cases, but you know, we felt it was, the whole idea was to not use everything that's from the house report, because we know that our occupancies are different.
But is it the same issue where you really need one or two? You don't necessarily need everything.
No, of course not, that's the whole point, right? So you're gonna get some, the cases come in with some sort of combination of stuff. And it's usually some of these things, it's not always all of these things, and we don't think that it would be all of these things. But just, you know, a lot of people wanted guidance. You know, we had one request that we should put in exactly what people have to have. I don't think we want to pigeonhole ourselves that way, because then if somebody doesn't have, let's say somebody doesn't have a bank statement, then we can't protect them, even though we probably should, you know, even though we should. That doesn't make sense either. So you have to be very careful in drafting rules. You don't want to box yourself in to a corner that you never meant to be in. So we felt that this was flexible enough that that the board could consider all kinds of proofs. And we definitely did not want to go to the housing inspector.
Did not want to go to it, but I understand from there that our proofs are landlord generally and tenant. Like if we back up a second and think of loft laws remedial, and we're just trying to make more life safety, more bring these buildings up to code, and we want the tenants safe.
Yes.
So our main goal is to make them safe.
But they have to be there.
And they have to.
We want them to be
all
there.
safe, whether they're Anne Franers or not. We want all of them safe, and
We want the people that are there safe, yes. But the question is, are they there?
Right, so the onus shouldn't be, the burden shouldn't be on the tenant to overly produce documents, so.
That's,
Not overly, just use some of these guidelines here to prove the timeline.
Right, so the more flexibility there is in that list, the better it would be for more.
yes. And I think
So
that
That's why
we have drafted this
that's
in a
why
very
number
flexible
4 is
way.
there, any other factor in the board.
I think we should think a little more about those factors. I mean, the local one you said you threw in there.
Yeah, I put it in there. I mean, I think it's a factor to consider. You know,
Children.
My son goes to like a magnet, like a different, it's not in my neighborhood.
That doesn't
that doesn't mean
disqualify.
that they don't live there.
Local, like, you know, like what,
No, that doesn't disqualify, but if someone else,
And let me say that
Child.
my kids did not attend those schools.
yeah.
No,
So-
just say.
so if someone else's child is going to that school, isn't that more of an indicia that the person lives at least in the general vicinity, right?
I don't.
It doesn't prove, I'm just saying.
I just want everyone, like,
So these are-
homeschool, whatever it is, you know.
Yeah, I think we can take that out. If you think
Uh,
that's problematic, we can certainly take it out. I know, you
Well,
know,
should we, I get your point. So nowadays, people are going to schools all over the place, right? So whether or not applicants' children, while registered in the school, has an address that's listed. Something like that,
yeah, that could be.
right? Is that, that were more sort of...
Well, if what you're trying to get at, if what you're trying to get at is that the occupant has a child who attends school.
No.
No,
Because you can homeschool
no,
somebody.
but it's certainly possible that now the kid could be in middle school 60 blocks away.
Or in another borough.
So where the kid goes to school could create an argument that, well, you must not live there because
No.
it should be where the school
No, but
has.
I'm sorry to interrupt, but,
Yeah.
yes, but that's what I'm saying. So at the time that child is registered in the school, then that address is what's being used for that.
By the school.
So,
Yeah, we can change that.
thank you.
I've got some more on this issue, but I don't know what our timing is.
We have 10 minutes, 9 minutes.
So I mentioned in passing that there's case law that I can find requires the rent stabilization standard in this context. I've cited it to you. I don't know how you're getting around it. I mean, there's a clear statement from the appellate division, second department, that interprets the Loft case from the Court of Appeals that's squarely on point, that says you need to apply the same standard in both contexts.
And there are also cases that say that these occupancies are different and you can't apply the same standards.
No, but this is exactly on this particular issue, exactly on point, on this very issue. I had sent you three cases on this, and as the general counsel for the agency, I'm not trying to be contentious, I just don't know how you're getting around it.
So I think we had discussed this, I would have to go back and look at my notes again, but I think we had had a discussion at a meeting about that issue, and that the courts have acknowledged that these occupancies are different. How is somebody who's on the road with a band going to prove that they were there 183 days when they weren't there 183 days because they're on the road with the band?
Now, that's okay in the stabilization context. If you're working away from home, those days count towards your being home. So that can be the issue. The stabilization standard has the advantage of 40 years worth of case law, so that all the issues like the ban, it's all been resolved. There are virtually no more open factual issues. It's 40 years worth of case law, and
Concerning a different type of occupancy. That's my concern.
I don't understand the concern because either you live either it's your home, it's your primary home, or it's not. Maybe we can talk after the meeting or sometime on these three cases specifically.
Sure.
So that I can better understand why the board is not bound by that. Because I don't think it's a stretch to say that we are bound by that. So why don't we talk separately?
Okay.
I have some more.
I'm just going to ask if you would, or you would, Blaine, circulate those three important documents.
Recirculate, Bishop.
Now, in terms of factors, where the address that you put on your income taxes, why is that not on?
Which one of the? your state income tax?
The federal.
What if you
Not
have?
everybody files.
Let me ask you, so, yeah, if you do, so, when you're filing of income, do you know what address that means? The state, what does that mean? Is that saying that you live at that location, you just live in the county or live in the state?
I believe for school tax purposes, in other words, the state divvies up some tax money back to localities. I think, I don't know for sure, but I think the address you put on has some importance in terms of being your primary residence. But I just think that there are some better factors to look at, especially the number of days where you sleep. Taking into account all the areas, work travel recessions that exist in the stabilization law. I just think those are better proofs. But I realize they're encompassed by the phrase, that you can use any factors that the House Board consider. But once you're listing them, it does give some special, I don't know, I think that it gives some special weights of factors.
So these are the ones that we took these from cases, right? I mean, so what has the board considered? The board has considered these things. So that's why we listed these things.
Right, but are there other things that you think are better?
Well, if there are other things that the board thinks are better, then we can add them.
Okay, so.
Again, a starting point.
Okay, so I suggest address on tax returns and the number of days that you sleep in the unit. I think in one of the options in the past, I think it made it in there, just as a proposal. Maybe I'm mistaken on that.
Is that fine?
No, it's a fact, it's a factor, so.
So next time, just ask other board members.
But it would be useful, I mean, I assume this list is going to be useful to a judge.
You want to add driver's license on there too?
Well, I think it has,
I'm just asking, because, some of these documents that you're saying, it was just as, like, a driver's license doesn't mean, you can put any address and use it as driver's license. So if you can do the same thing for an income tax.
No, but income tax in the law carries some weight. You may be stopped to deny that address in some context. So
in the housing code context, yes,
Yes,
it's a case that says just that.
Yeah, so that's.
The board hasn't gone there yet.
That's not to be taken lightly.
No, I understand that, but the board hasn't gone there yet. Again, this is a list of things the board has considered, with the exception of school. I'm really sorry, but it's school. No. So, what we codified here in 1, 2, and what should be 3 is stuff that the board had already looked at. So the board has not, the board has talked about taxes, but it hasn't been discussed. So, I think you're making a motion to say, can we add those to the list?
Well, at first I want to know if the staff thinks it's a good idea.
Well,
I'm not-
the way we're going to find it's a good idea is actually through a vote at this point. If we just make a motion as to what you want to see on there, and we'll see what the other.
Can we do those separately, taxes and
No,
number of days?
unless,
I would vigorously oppose it, but your tax day is all right with me, but number of days could be that
So let's do
somebody working out of town more than half a year, so then to say that they don't live there because
so Mr. Carr,
they're working out of town.
I got it. I want to make
That's
this,
very possible. So I completely object to that.
Mr. Carr, motion one at a time.
Let me take it next time so that I can make the number of days a little more clear as to what I'm getting at, which would be, it's more than half a year, but the travel days count towards you being there, even if you're not, So I'm happy to do that, but it has to be done correctly.
I got you. It seems a little burdensome also, right? What you say?
I think proving the truth is not burdensome.
Yeah, yes, it is. It can be. Okay, so this,
Mr.
Yes.
Chairman, I'm sorry. Before we adjourn, I would like to make one statement and one request. The statement is that without having discussed primary residence, which is the 800-pound gorilla in the room, getting into specifics of proving occupancy is setting things up in a way that I think. I would really like to turn to the issue of primary residence, which we've skirted for the past 2 3/4 hours. That's my statement. And my question is, the board is meeting twice next month. It's meeting on October 11th, and then it's meeting to do cases on October 18th. I would like to know now what we're going to be discussing on October 8th, and if we're...
October 11th?
On October 11th.
Let's do primary residence. I think that's fair. So I think what we say, Mr. Delaney, is it's premature to ask for a list of factors to prove it if the board hasn't decided it has to be proven.
Can I just read 2 paragraphs? I think it would give everybody something to think about. This is from an attorney who said, I suggest you emphasize the burden on tenants to prove primary residence and how some landlord attorneys have turned the discovery process into flat-out harassment. I've had cases where the landlord's attorney has demanded 30 or more categories of documents amounting to thousands of pages. The date of the hearing requirement also creates a permanent rolling discovery period where tenants can be required to keep producing documents up to the day of trial. Finally, all of the standard problems with primary residence, that's close, primary residence documents, e.g. failure to change addresses on accounts, licenses, other documents, have made trials much longer and more expensive as landlord attorneys spend time on these distractions, even though there is no good faith claim that, say, the 30-year-old tenant employed in New York City actually resides with his parents in Texas. I have recently had 2 clients drop their claims because they didn't want to go through a hostile cross and incur thousands more in legal fees. So ultimately, if we keep this primary residence requirement that we've drawn into protected occupancy to be covered, then where your kids are going to go to school isn't going to make any difference because you're not going to get that far. Thank you.
Yeah, I would just add to that too, my hesitation with the draft that we received. I feel like if I could Google how many times primary residence is written into the new rules versus the previous rules, like it seems like
It's there more.
much more.
It's absolutely there more.
Well,
There's no
well-
question. We've had a lot of issues with whether or not people are living there. We've had all kinds of Airbnb allegations. It's been really bad. So, you know, you weren't at the meeting where I said this, but I view this as a huge gift to the people that live in these spaces. And the fact is that there have been abuses, and somehow we need to address that. So, you know, we've had situations where tenants have had like 3 apartments in 3 different buildings. How could that be? Right? You can only live in one, well, I guess you can live in one place. So that's where it's coming from. Okay, it's coming from having seen abuses and allegations of abuses. And there are times where tenants will leave. They'll just leave because they're not there. The landlord found out they're not there, and they come to some sort of agreement, and the tenant's gone. So that's where it's coming from. It's to preserve affordable housing. That's the
Okay,
idea.
it seems like it's doing the opposite, so I guess that's where we start.
So you think people shouldn't live there?
No, I just think if we're dealing with like the 1% that's the bad eggs instead of the overall grand scheme, then we're missing the point of what we want more tenants covered in that. It puts a burden on them to always first of all, they started in an illegal building, that the landlord was doing something illegal. Like, so they're like, hey, government, help us get to a final C of O here, versus spending hours and thousands of dollars proving their primary residence. Like, it seems counter to, like, it's treating, they're the ones that told on a criminal and they're trying to do right, and then the burden's on them now
So this is a much bigger discussion for this kind of day. Because I can give you a lot of, counter arguments.
Well, so maybe
to that,
you
and I
don't
don't
have like a little paper on what you're, just like the intern presented, because I don't understand your viewpoint, and I'm hearing from lawyers the opposite of what you're saying, so I'm trying to.
So let's assume we gave protected occupancy, we didn't require where we gave protected occupancy. Then then we have rules that the landlord could drag the tenants into housing court and sue them there. So then they're paying the money in housing court. So now the law court has spent all of this time, right, and effort, and given somebody protection, and maybe they didn't deserve protection, and the tenants are paying the money anyway. Because they're going to pay it in housing court. They'll pay it in Oakland, they'll pay it in housing court. And the fact that the landlords are exercising their rights, they have rights. And if the discovery process is being abused, then it's up to the tenants' attorneys to say to the oath judges, this discovery process is being abused. My tenants should not have, my clients should not have to pay 30,000, should not have to produce 30,000 pages of documents. That's why they have a lawyer.
Do you think the abuse is within?
I think that landlords are going to landlord attorneys are going to vigorously represent their clients, and I think that tenant attorneys are going to vigorously represent their clients as well. And that if a tenant attorney feels that there are abuses, the proper channel for that is to take action and not read a statement that says there are abuses. That's my opinion. If a landlord has 30,000 pages of documents, an attorney should say that's too much, Your Honor, you need to limit discovery. And the judge should take that into consideration. That's what should happen.
Simply because there are abuses and everything.
The problem with the issue is that often you have a group of units in a building seeking coverage. And if there is one unit where there's a primary residence issue, and that becomes an issue of debate prior to determining coverage, then that means all the parties to that suit end up having to share the legal costs for that.
And so the answer to that is to sever the issue. I mean, we could go around forever on this.
It's already appropriately severed because once the owner registers the unit, and I would encourage all the board members, I know it's lengthy reading, but the petition that was submitted on behalf of Dumbo Neighborhood Association goes into this in great detail. The real responsibility to be a primary resident comes once you are a protected occupant.
I disagree with that.
You disagree with?
I disagree with that statement. That is an incorrect statement.
You mean from the petition or disagree?
From the petition. That's an incorrect statement of the law, in my opinion, and it hasn't been litigated yet. But the law clearly says you're entitled to continue in occupancy and it's to prevent dislocation. So that means you're there. To me, it's just a plain language thing that's being contorted.
Well, perhaps then it would be helpful if at the start of the next meeting you would walk through, I'd say roughly pages 5 through 9 of the arguments in the petition.
And I already did that, but I'll do it again.
Thank you.
When did you do that? Because I'm also a newer member, so like.
This was a year and a half ago. I think.
September 28th, 2017.
A year ago. Okay. This will.
That was the crux of the issue that came out. Good.
Great. This will conclude our September 27, 2018 Loft meeting. Our next public meeting will be held 2 April, right here, on October 11, 2018 at 2 p.m. Board members, please sign and hand in your attendance sheets. And that also asks to please police your areas as you leave. Just take whatever you took with you. Thank you.